Okay.
Welcome. We're very lucky today to have a professor of law at Ohio Northern University, Scott Douglas Gerber, who is, as far as I know, the world's leading authority on Justice Clarence Thomas, and as well constitutional law in general. He got his law degree and a PhD from the University of Virginia, and he also went to the College of William and Mary. So perhaps one day he'll be governor of Virginia. And then author of several books, novels about the law, The Art of the Law, Mr. Justice, but also serious scholarly works, A Distinct Judicial Power, The Origins of an Independent Judiciary, 1606 to 1787, The Declaration of Independence, Origin and Impact, and so forth. And of course, The Jurisprudence of Clarence Thomas, which is the best book on Clarence Thomas's jurisprudence. As far as I know, it's the only major book on Clarence Thomas's jurisprudence from a objective scholar. So I really thank you for the opportunity to talk to you today. Someone who knows all about the Supreme Court, who knows a lot about Clarence Thomas, and we're going to talk about 5 topics in 45 minutes. So it's going to be a quick and very concentrated discussion. First, we're going to talk about the conservative nature of the recently completed Supreme Court term. Then we're going to talk about what Professor Gerber thinks are the 5 most important decisions. 1, overruling Roe versus Wade. 2 and 3, 2 religious liberty cases, the main case for vouchers, and the other case for the high school football coach who was praying on the field. Then the Second Amendment case written by Clarence Thomas, which I think is Bruner, and finally, the West Virginia versus EPA case. Then we're going to talk about a very controversial idea that Professor Gerber has, is that Gorsuch and Kavanaugh should be impeached and removed and replaced. And I haven't heard that one before. And perhaps it's going viral. I don't know what the reaction is to that, but he'll tell us why he thinks that should happen. Then we're going to talk about the newest justice, Ketanji Brown Jackson, and what her judicial philosophy might or might not be. And finally, we'll come back to Clarence Thomas's increasingly prominent role, and especially what it might mean next term when there are going to be some affirmative action cases on the docket of the court. So that said, I'm going to turn it over to Professor Gerber, and I'm just going to ask him to quickly summarize what are the significant points of the 5 top cases decided this term.
Okay, so the first one, the Dobbs case, obviously the most important point is that it overruled Roe v. Wade and Planned Parenthood versus Casey. So according to the Supreme Court, there is no longer a right for a woman to have an abortion protected by the US Constitution. So that's a seismic decision. It's the first time the court in its history has taken back a right they previously conferred. So there's that one. The next 2, there was a religious liberty case out of Maine, where because of Maine's rural nature, there were some school districts that could not finance public schools. And so parents were given vouchers and allowed to send their kids to private schools as long as they weren't religious in nature. And the Supreme Court said the Maine law was unconstitutional, violated free exercise of religion. On the football coach case, he prayed after games, high school football games, public high school. He was fired for doing it. And the US Supreme Court ruled for him, said he had a free exercise and a free speech right to pray, and overruled the Lemon Test, which was a very convoluted and much criticized approach to the Establishment Clause. So like the prior religion case I just mentioned, it was a victory for the free exercise of religion, which is also protected by the First Amendment. The fourth of the major cases was the gun case out of New York, where New York said that in order to carry a gun outside your home, you had to prove that you had a special need for it, which meant you had to prove you had specific threats to your physical safety. And the Supreme Court invalidated that as well. And Clarence Thomas wrote that opinion. And then the final case was a more technical case involving statutory interpretation, where the EPA was denied the right to regulate climate change unless Congress has a statute that directs them to do it. And that was an invocation by the court through Chief Justice Roberts of what's called the major questions doctrine. So if an agency is going to take on major policy concerns in its regulations, it can't do it unless Congress authorizes it to do it. So that's that one. Those are the cases.
And do you connect that to your first point about they are showing a conservative nature of the new Supreme Court?
Absolutely. The conservative position won on all five. Absolutely. And studies have already shown, they've already come up with statistics, and this has been characterized as the most conservative Supreme Court term since I think the year was 1931. So almost 100 years, almost 100 years. And so before we started recording, we were talking a little bit about Chief Justice Roberts and his inability to persuade his colleagues not to overrule Roe. As I would discuss with my students sometimes, the younger justices now on the court, on the conservative side, were professionalized in the conservative legal movement, the Federal Society, the Heritage Foundation, things like that. And overruling Roe was front and center on that agenda. And so they just did what they were professionalized to do. So it was a major victory for like the Federal Society and the Heritage Foundation and groups like that had played a major role in the advising Republican presidents about who to put on the federal courts, but the Supreme Court in particular. So that's why it was so conservative, and that's why Roberts was, in my opinion at least, unable to persuade his conservative colleagues to hold their powder on the Roe case. He was willing to uphold the restrictive Mississippi law, but he did not want them to overrule Roe. And we can talk about that in more detail if you want.
Yeah, let's talk a little bit. Why do you think that happened?
Why? Which part? Why did Roberts not want them to do it, and why did they ignore what he said?
Yeah, both.
Yes. Well, when Roberts was being confirmed, and this relates to what Gorsuch and Kavanaugh did, but when he was being confirmed, he actually said what he ended up doing, and that was that he felt that that Roe was an important precedent and people should be very careful about overruling it because a generation and now 2 generations of women have come to rely on it and all of that. And that's exactly the approach he took during oral argument in the spring, and exactly the approach he took in his separate opinion in this case. But he was unable to persuade Alito and Barrett and Thomas and Gorsuch and Kavanaugh, because as I've said, they were professionalized in this conservative legal movement, and they had strong feelings about the case, and they didn't care what he wanted them to do or hoped that they would do. They just did.
But your analysis here is not really legalistic. You're just saying it's because they come out of a movement. In other words, when I read the case, there was a tremendous amount of discussion about history and society and precedent. In other words, they seemed to be making a legal argument as well, that they just weren't following orders from the Federalist Society.
Yeah, I didn't mean they were following orders. It's just that they were socialized and professionalized in an environment that wanted the Constitution read in a particular way. And, and what a lot of these cases for this term have in common is this victory for the approach of looking to history and tradition to decide what the Constitution means. And so Alito, in his massively long opinion, said that there's no history and tradition of allowing a woman to have an abortion. And again, they're not saying that the states can't allow it, but they're just saying that the federal Constitution doesn't protect it because there's no history and tradition in our country on that. And so that's what the originalists want. That's what Thomas had always wanted. That Scalia wanted that. Alito did it in the case and things like that. And so it's an approach that has emerged as very significant on the court now.
So you're actually saying it's based in a judicial philosophy of originalism. It's not that they just get a text from Heritage saying overturn Roe. They have a philosophical basis for this.
Right, and that'll then relate in some way to what we say in a few minutes about the newest justice. And yeah, there's several approaches, methodologies to interpreting the Constitution. One of them is the one that the conservative legal movement has embraced. And that's the one that's carried the day, especially this term. And so people debate, at least in my line of work, whether these methodologies are just politics dressed up to appear neutral or not. And that's a sort of a debate for a seminar, but yeah, they've picked this method that Scalia was a champion of, that Thomas is a champion of, that Bork was a champion of, and all of that. And so that's what they employed in these cases for the most part. But
you would say from this that Roberts is not an originalist based on what he wrote.
No, he's not. And in that, and again, these all tie together. I mean, the people think in different ways, but I'm like a conceptual, theoretical guy, so everything kind of fits together in my head. But when I wrote the op-ed about Justice Jackson for USA Today, I outlined what the 6 main approaches to interpreting the Constitution were. One of them is what's called doctrinalism, i.e. just applying precedent. And Roberts is that, right? And so, as I mentioned already, he testified that way at his confirmation hearing, that he was committed to this idea of stare decisis. And under that theory, even if you personally think a decision is wrong, if it's been relied upon for generations or something, be careful about overruling it. So he would be more of a doctrinalist than an originalist.
So you've got on the conservative side, doctrinalists and originalists. Would you say that's it for the conservative side, or are some of the conservatives, like Gorsuch was supposed to be a libertarian? Do you think that fits, or?
Yeah, and as I said in the piece, these are not all mutually exclusive categories. And so textualism, for example, is closely related to originalism. So Scalia was a textualist. He first wanted to see what the words said, but if the words could be interpreted in more than one way, he then wanted to ascertain what the original understanding of those words was by the people that wrote them, right? So that's very closely tied to originalism. And then there's what's called structuralism. How do the various clauses in the Constitution fit together? And that too is typically a conservative approach.
And which justice would that be?
The one that I mentioned in the piece was the most highly lauded Supreme Court justice ever, and that's John Marshall way back in the day.
Okay, but not on the court today.
Right, not on the court today. And then in terms of your question, but isn't Gorsuch a libertarian? And so one of the last approach, the broadest approach, is sort of ethical, moral, philosophical. And that would be, okay, people have this kind of, in his case, libertarian mindset. And then they read the text with that in their back of their head, or they read the history with that in the back of their head. And so as I've tried to say, these methods aren't just pigeonholes. They all kind of weave together. And the biggest debate, I think, at the moment is if a precedent is not consistent with, say, originalism, how much weight should you give to the precedent? And so Thomas essentially said none, and Alito has essentially said not much, et cetera, et cetera, et cetera. And Roberts has said a lot. So all of these are kind of tethered together and interrelated and all of that. So that's why we have a whole seminar on it in law school.
Okay, but it's interesting to give context to the people watching this video, whoever they might be. Let me ask another question. Can you do the same categorization for the liberal justices?
Yeah, absolutely. The easiest one is Breyer. One of the 6 methods is what's called prudentialism, i.e. policy. What's the best policy that would result from deciding the case this way or that way? And Breyer is that. Breyer is that. So he filed a dissenting opinion, for example, in the Second Amendment case that Justice Thomas wrote the majority for. And he just said, the best policy is to have fairly strict gun regulation, because if we don't, people are going to get shot like they've been getting a lot lately. So he's that. I think Sotomayor is more this bigger one, this sort of moralism kind of thing, like Thurgood Marshall was. Just what's the right thing to do kind of thing. So she's like that. Frankly, I don't know. I haven't thought as much about Kagan as maybe other people have, or maybe as I should. So I'm not sure what I would call her. So those are the 3.
Okay, but I think it's helpful to make categories so we have an understanding. It's not just personalities or politics. There's some intellectual content to it as well. So I thank you for that. Let's now talk about these other cases. What do you see the importance of the religious liberty case being, the 2 cases?
Yeah, well, just coincidentally, I have a book coming out next year that I've finished the edits on, and I'm just working on the index right now, but it's called Law and Religion in Colonial America, and Cambridge University Press is doing it. And so obviously I'm deep in the religion stuff. And in the op-ed I wrote for the New York Post about the case out of Maine, my point was for that my research on that book has made it clear to me that the United States is committed strongly to the free exercise of religion, and that the Establishment Clause does not mean the free exercise clause is meaningless. And there's this famous phrase that Jefferson invoked in a letter in 1803 or 1804 to the Danbury Baptist Church about the importance of a wall of separation between church and state. And that the Supreme Court then read into the Constitution in the school prayer case out of New Jersey, the Everson case. And so, my point in the op-ed was Jefferson messed up the metaphor. The metaphor originally was pronounced by Roger Williams of Rhode Island, the principal founder of Rhode Island. And Roger Williams was a zealous proponent of the free exercise of religion. He was banished from Massachusetts Bay because Massachusetts Bay had an established Puritan church. He thought that was inappropriate. People should be able to worship as they please and all that. So they threw him out. He founded Rhode Island, and he comes up with this metaphor, and I quote it in the op-ed. And so Jefferson then distorts the metaphor to put up a wall between church and state. What Williams was talking about was the need to protect the church from the corruption of the state, not the other way around.
Okay.
And so in this case, the dissent, Sotomayor and Breyer, both separately, they both said, we're violating Jefferson's metaphor is separation of church and state. And so my point was, Jefferson was wrong, right? And so Roberts got that right. A lot of people might not think highly of Roberts, but he got that part of it right. So we were committed to the free exercise of religion well before the First Amendment was ratified, well before that.
Okay. And then what about Clarence Thomas's Second Amendment case? Because this may be, in a way, the most consequential, because look at all these shootings we've had in Uvalde, in Highland Park, and so forth, all over.
Yeah, so Thomas is actually, I think he's responsible for getting the Second Amendment cases front and center on the Supreme Court. Way back in 1995, when the court decided a Commerce Clause case called U.S. versus Lopez. That was about the Commerce Clause. But Thomas threw in there, it might violate the Second Amendment. So he kind of planted the seed. And then the 2008 Heller versus Washington, D.C. case comes up, and the Supreme Court, in an opinion written by Scalia but joined by Thomas, says that the Second Amendment protects an individual's right to bear arms, not just a militia. Okay. And then in this most recent case, New York had a law that said that if you want to have a gun outside your home, you have to prove to the government that you really need that. And so the burden was placed on the person that possessed the individual right. And Thomas said, the burden is on the government to prove why they need to regulate this fundamental right. And you can't flip the burden and put it on the person that enjoys the constitutional right. And he then said, unless there's regulation of the type that New York had in the history and tradition of our country, that regulation is out. And he concluded there was no such history and tradition. So he said that New York's law violated the Second Amendment. And then, Kavanaugh then writes separately, and he says, yeah, I agree with that, but that doesn't mean that the government cannot regulate reasonably weapons. And he then cites back to Scalia's opinion in the Heller case out of DC itself that I quoted in that prior op-ed I did for the New York Post about after the Uvalde thing, where I essentially said that we got to stop just kowtowing to the NRA when little kids are getting slaughtered, because no right is absolute. So there is a Second Amendment individual right. I agree with that, but it doesn't mean that you can't reasonably regulate.
Yeah.
So that was my take on that.
Okay. And what's reasonable, of course, becomes debatable, especially in the Uvalde case, where it seemed that the police were letting people be shot. But we'll continue. What about going on to the, did we do the West Virginia EPA case already?
We touched on it briefly.
All right. So I see this, they sent me a notice. I'm on a free plan and this is going to run out in 5 minutes. So let's talk quickly about that. Then I'll have to shut down and we'll have to start part 2 and with a new video. So why don't you quickly go why you think Gorsuch and Kavanaugh should be removed?
Okay, so I had an op-ed fairly recently in the National Law Journal where I said that they deliberately misled the Senate about whether they were going to vote to overrule Roe and Wade. And I quoted some of their testimony in the op-ed, and other people have compiled all of their testimony. And it's even, it's pretty obvious that they were just trying to tell the senators that they needed to go their way like Collins and Manchin, what they wanted to hear, because I don't think Collins or Manchin wanted Roe overruled. And so they misled them deliberately, in my opinion. And I don't think that we should have people in positions like theirs that essentially don't tell the truth to get the position. And other people told the truth and they got confirmed. So Amy Coney Barrett, she also wanted the job, obviously, as almost any lawyer would. And she said, people are calling for it to be overruled. It's not what people call a super precedent like Brown v. Board. No one except maybe the Ku Klux Klan thinks Brown v. Board should be overruled. And so that'll never happen. But she said Roe is not that. People call for it to be overruled all the time. So she didn't mislead them. And the same with Roberts. I already told you what he said, right? He said that if there's a precedent like that that's been relied upon for so long, the court should be careful about overruling it. And true to his word, he voted not to overrule it. And then one other example, Ruth Bader Ginsburg, when they're always asked, these nominees, what do you think about Roe? Okay. And so she said that Roe is central. The right to choose is central to a woman's constitutional right to autonomy. And so, yes, she said Roe is correct. It shouldn't be overruled. And she was confirmed 97-3. So I just didn't think that Gorsuch and Kavanaugh were being honest. And there are, as I've said in other contexts, we also have to get past this notion that these 9 people are so special that they must be up there. There's no one else that could do the job. As I also tell my students, there are thousands of people that could do those jobs just as well as, if not better, than the 9 people that we have up there now and previously.
Well, that's quite a strong statement. Let me ask you, since we have 2 minutes left, you're an expert on Clarence Thomas. Do you think he was truthful when he testified?
Yeah, one of my friends asked me that, and so I know there, and the origins of my friend's question to me was there was an article, I think this weekend in the Financial Times, and he said the author of that op-ed or whatever it was said that Thomas lied about it also, and it was behind a paywall, so I couldn't read what he said. But I do recall what Thomas said, and he said that because he was raising a young family at the time he was in law school, that he didn't have time to talk about Roe, and he never thought about it too much and all of that. I find that I'm skeptical of that, to be candid about it, but that's his position.
He didn't say he would never overturn it and then turn around and overturn it. He sort of
correct, right? He just said he didn't talk
punted,
about
as they say.
Yeah, he punted. He said he was focused on just taking getting through his courses in law school and helping his wife raise their young son.
So he declined to answer. And then the Ketanji Brown, which I mentioned to you earlier, she said she couldn't tell the difference between a man and a woman because she wasn't a biologist. Do you think that was a truthful statement?
I didn't hear the statement, but do I think it's an accurate statement? No. Do I think she was being dishonest when she said it? I don't know what's in her head.
So you're giving her a softer treatment than Gorsuch and Kavanaugh, because on its face it struck me as absurd. But if you're willing to accept that as bona fide, I'm not going to question it. We have less than a minute, so we have to shut this thing down, and then I have to get you back to do part 2. Thank you. This has been absolutely fascinating, and I think we'll get some viewers just on the Gorsuch and Kavanaugh issue alone. So stay right there. We'll be right back, and thank you. Okay,
right.
bye-bye.
Bye.